Let me ask how you react to a lawyer.
It's a very impressive, almost awesome experience standing there in that wonderful courtroom with the justices looking down until the first question. There's this perhaps tension, and then it falls away. And the most exciting experience in arguing before the court is feeling that there are 9 people and yourself, and you're having a conversation, and you lose a sense of there being anybody else in the courtroom. It's a remarkable experience.
Now, American lawyers usually argue before either one judge, sometimes 3 judges, occasionally 5, but to argue before 9 is a different experience because you're arguing before a corporate group, and they all have their own ideas, and they ask you questions, and they use you sometimes as a post office box to talk to each other, and one justice has one idea that he's pursuing with questioning, and another justice will have another idea that she's pursuing with questioning, so that you have to simultaneously juggle in 30 minutes, sometimes 3 and 4 different lines of thought being drawn out of you by the justice's questioning.
There's an old principle. There are 3 arguments: the argument you planned to give, the argument you gave, and the argument you wish you had given when it was all over.
We have the luxury on this court nowadays of just plucking out of that very complicated case the one issue that seems to us of national significance and just concentrating the entire oral argument and all the briefs just on that one issue. That's a great luxury.
People will sometimes ask you, does oral argument make a difference? Of course it makes a difference.
It makes a lot of difference.
It has to make a difference. That's the passion and the power and the poetry of the law, that a rhetorical case can make a difference because abstract principles have to be applied in a real-life situation, and that's what the lawyer is there to remind the court about.
Within a few days after hearing arguments, the justices gather in their conference room to vote on the case. In this room, the 9 are alone. There are no law clerks or even a secretary. After they vote to decide a case, one of the justices on the majority side is assigned to write an opinion explaining the legal reasons for the decision. Opinion writing is the most time-consuming part of the justice's work. The court's reasoning in a written opinion binds all other courts as they decide future cases. Law clerks assist in researching and drafting opinions, as well as preparing for oral argument and screening the flow of new petitions. In addition to the majority opinion, any justice may write a separate opinion, dissenting from the decision, or concurring in the result, but disagreeing with the reasoning. Normally, a first draft of the court's opinion is finished in about 4 weeks. Opinion drafts are sent to all 9 justices. A justice may redraft a dozen or more times in the effort to persuade the others to join the opinion. Revisions and adjustments may go on for months as the author tries to accommodate differing views. Compromise is inevitable. On difficult cases, a justice switches sides, and on rare occasions, the majority becomes the minority. With rare exceptions, the court's tradition is to announce decisions and release opinions for all current cases by the end of the term in late June.
Yes. Thank you. 95-566.
As the justices announce their decisions in the courtroom, the public information officer is notified by telephone to release copies of opinions to the press. Working against deadlines, reporters attempt to explain briefly what the court has decided and the reasons.
They're books. One is 80 pages long, the other one
Supreme Court correspondents rely primarily on the court's written opinions, which run from a few pages on a unanimous decision to 80 pages or more when a divided court writes separate opinions. Within hours, or even minutes, they will be in print or on the air, explaining what the court did and its potential impact for millions of Americans.
Scalia wrote the opinion along with Rehnquist, Kennedy, Thomas.
Decisions on civil rights, criminal procedure, taxes, labor law, business.
One from Texas and one from North Carolina. In the Texas case,
when the Supreme Court speaks, by and large, people obey. And that unspoken contract is one of the hidden keys to our freedom. If the court ever stopped defending the Constitution, or the people ever stopped listening, then one of the treasures that keep this the freest nation in the world would cease to exist.
People see in that institution a willingness to protect the unpopular, to stand against the temporary political tides, a concern for principles beyond today's politics. People want to know that there's some institution in this country that's taking the long view.
Most people are willing to accept the fact that the court tries to play it straight. That acceptance has been built up by the preceding 100 justices of this court, going back to the beginning. We are, in fact, trading on the good faith and the conscientiousness of the justices who went before us. The power of the court is the power of trust earned, the trust of the American people.